Morning, everyone. I'm so happy to see so many familiar faces, and it is my honor to introduce Ahmed El Khamloussy, who started his linguistic journey in Morocco. He earned English and American literature degrees and a degree in Arabic English translation. Then he completed a Master of Arts in Translation and earned a graduate diploma in conference interpreting at the University of Ottawa. He has worked as a conference interpreter for the Canadian Parliament, and he also served as Arabic interpreter for successive Canadian prime ministers for over a decade. Currently, he is a senior French booth interpreter and Arabic booth supervisor at the International Criminal Court in The Hague. Now, I know this is unscripted, but I do have to mention that I had the opportunity of meeting Ahmed at the ICC. He gave some of us a wonderful tour, which I will remember forever. Ahmed has also been involved in training interpreters in languages of lesser diffusion at the ICC and has collaborated with institutions like the University of Ottawa and Glendon College. And he has also provided training for prospective interpreters for the International Committee of the Red Cross, which is the ICRC. So back to, or now I think Ahmed has the floor.
Thank you very much, Chris. Thank you, Tony and Katerina, for inviting me. It's really a pleasure to see you all, and thank you for all the participants who took the time on a Sunday to be with us. To begin with, I would like to make a disclaimer. While I am indeed an interpreter at the ICC, and I've been authorized to speak to you, I am in no position to be an official spokesperson for the ICC, so whatever opinion I might express today is mine and mine alone based on my own experience and observations. I will be using a PowerPoint presentation, so bear with me. I will not be reading it, so that's perhaps a good thing. To begin with, the topic that I chose to speak about today is interpretation at the ICC. I will be referring to the particular characteristics of interpretation at the ICC, but more importantly, I will be focusing on a specific example of a language of lesser diffusion, which we call differently at the ICC. We call it a situation language, and how we had to come up with a solution and train interpreters for that specific case. So just briefly about the ICC, from Nuremberg to Rome, then the ICC. We didn't come out of the blue. We are the continuation of something that was started at the end of World War II. You're all familiar with the Nuremberg trials. It's the birthplace of international criminal justice, but also the birthplace of simultaneous interpretation. That's why it's so meaningful for us. Then there was the Tokyo around the same time, Tokyo military trials. The ICTY, the International Criminal Tribunal for former Yugoslavia, which was also based here in The Hague. The ICTR, the International Criminal Tribunal for Rwanda, based in Tanzania, in Arusha. The Special Tribunal for Lebanon, which was also based here in Leedschendam, which is close to The Hague, for Lebanon. The ECCC in Cambodia, Kosovo, also based here in The Hague, and Sierra Leone, which was partly, where hearings were partly held here in The Hague. What all these trials and jurisdictions have in common is that they used interpretation, but unlike the ICC, the number of languages was limited. For example, at the ICTY, it was English, French, the official languages, but also the BCS, Bosnian, Serbian, and Croatian. ICTR had English and French, and Kinyarwanda and Swahili, and so on and so forth. STL had Arabic as well as an official language. When it comes to the ICC, you name it, we have every language you can think of, and even some that I had never even thought of before I joined the ICC 15 years ago. The Rome Statute is the treaty upon which our court is based. It is the first permanent court of this nature. And in the Rome Statute, there's a provision. Specifically, it was adopted by 120 countries in 1998 at the end of the Rome Conference. In 2002, it came into effect, and in 2025, we have 125 states parties. And there is one particular aspect about language that I'll refer to in a second. These are the areas of jurisdiction that we have at the ICC upon war crimes, crimes against humanity, genocide, and crimes of aggression. And Article 50 specifically defines the languages of the court. There are three different regimes. The first one is what we call working languages, English and French. On a daily basis, inside the courtroom or outside, you can use either language to work. Then we have the official languages of the ICC, which are also the official languages of the UN, Arabic, Chinese, English, French, and Spanish. And then the novelty at the ICC is that we have what we term the situation languages. That's the language of the suspect or the accused person and or witnesses and victims who come before the court. So far we've had Arabic. Although Arabic is an official language of the court, it is also a language of situation in Libya, in the situation in Darfur as well. Then we've had Swahili, Sango, Acholi, Lingala, Songhai, Jula, Lendu, Lingala, Tamashek, Zagawa, and Fur, among others. And what all these languages have in common is that there is no recognized in interpreting conference interpreting school anywhere in the world for these languages. So we've had to do our own training, and in some cases with great success. The example of Sango comes to mind, which was one of the best success stories we've had. Colleagues who have become full-blown interpreters and have been working with us for years now. Now, language rights, why do we have to bother with these so-called situation languages? Because the Rome Statute has this obligation. It's called the linguistic rights of the accused. As part of the due process, Article 67 of the Rome Statute specifically says, in determining any charge, the accused shall be entitled to a fair hearing conducted impartially and to the following minimum guarantees. And one of those guarantees, I only mentioned the one that is relevant, is to have, very important, free of any cost, the assistance of a competent interpreter and such translations as are necessary to meet the requirements of fairness if any of the proceedings or documents presented to the court are not in a language which the accused fully understands and speaks. So if the accused fully understands the language, it's not a problem. It's only an issue when they raise this, they avail themselves of this, this possibility and say, okay, well, I don't fully understand and speak. And just in passing, perhaps, I highlighted fully understand and speaks because the French official translation of the Rome Statute went a bit too far, just a step too far. And it was translated as comprend et parle parfaitement, which means perfectly well, which is also a problem in itself because you may be fluent in a language but not necessarily speak and understand it perfectly well. So a fair and expeditious trial, what are some of the pillars of that? There's the legal imperative. The trial chamber shall ensure that a trial is fair and expeditious and is conducted in full respect for the rights of the accused, including their linguistic rights. And when it comes to actually applying that right or implementing it, we resort to two modes of interpretation, mostly, simultaneous and consecutive. And this is determined usually in consultation with the chamber and with the language services sections to whom I belong. Who are the interpreters at the ICC? Well, there are, as I mentioned, two categories, the official working languages interpreters and then the situation language interpreters. The first category is basically university-trained conference interpreters. Usually they hold a master's degree or above. And they tend to be seasoned interpreters. I think for a P3 position, you need at least 5 years of, a minimum of 5 years of experience within an institution, international institution, or 7 years for a P4 and above. Then some of our colleagues came from the ICTY, some from the ICTR, so they had that legal experience and background. Myself, I did not have that background. Then we have the situational languages, and the profile is somewhat different now. Some colleagues have some prior experience, mostly in field interpretation with UN missions or NGOs in the field. Some did not. A lot of them, depending on the language, come from the diaspora. For example, because of the civil war going on in Sudan, we had to go to some diaspora communities in Europe and elsewhere to find potential candidates. They tend to be refugees, asylum seekers, or just people who are settled somewhere else. And then we have to resort to in-house intensive training. We had to design on our own and build on the experience from one case to the next. How do we identify potential interpreters for situation languages? First of all, because of administrative reasons, you have to announce the vacancy. But you have to reconcile that with the imperative of being discreet, because if there's a civil war going on, or if there's a potential warrant of arrest against an individual, you don't want to alert them ahead of time and give them time to either um, abscond or do something, continue on with their illegal activities. So you have to be very discreet and ensure confidentiality. If the warrant is under seal, it hasn't been made public yet, so how do you announce that without violating that principle? Then you have to do some aptitude testing, just initial testing to see if there's a potential there. But then you're also confronted with a major issue, lack of material, as we will see soon. When it comes to certain languages, where do you draw the material from? And then the personal resources, in the sense that the pool of potential candidates is very limited to begin with. And finally, there's the strict security vetting. To become an interpreter at the ACC, even for the English or French booth, you need to go through a very strict security vetting process. But if you're from a community where there's war, then that challenge may be compounded. Because if you're from a small community, chances are you're related to the accused or to the victims, and then that may cloud your impartiality, perhaps. In-house training. So we have to design our own training programs. We start off with consecutive interpretation because we believe in it, and just like in any conference interpreting school, because it is the foundation that allows you to test your analytical skills and also your memory and your understanding. Then we move on to simultaneous. In some cases, this was the case with the Sango colleagues. They were already, they had a solid background and they had enough time to be trained, and eventually made it to the booth in simultaneous mode. Then you also focus on the ethics of interpreting. As I mentioned, if you're a potential candidate and you come from a community where most of your friends or family have been killed or mistreated by the community to whom the suspect or the accused belonged, or in the hands of that individual, you might want to focus a lot on ethics and how you can keep your distance and neutrality as an interpreter. Then you have, and this is a major hurdle as well, finding the appropriate training material in unwritten languages. I say unwritten because Zagawa and Fur, two of the main languages spoken in Darfur, Sudan, are oral traditions. They don't have any written form for the most part. So whatever material you'll be using, it'll be oral only. So how do you do that, and how do you go about it? Then you have to work a lot on upgrading the B language skills, because the situation language is the pivot booth. For example, in Sango, the witness is testifying in Sango and it's interpreted in French. So French has to be very good, and it is the case with the Sango colleagues, for example, so that you can rely on it and take relay for the English booth. We've had the same situation with recently in a Darfur case with Arabic and Fur. Fur interpreters would work into Arabic, and then the Arabic booth takes over and interprets into English or French. Then you also have to focus a lot on building understanding of the court, because interpreting, as you all know, is not just language or terminology, it's also procedures, facts and circumstances of a case, the role of parties, participants, why confidentiality matters, what does that mean in concrete terms. So who is who in the courtroom? I mentioned it's important to know the procedure and the roles and responsibilities of everyone. So if you haven't been to the court, the ICC, this is what it looks like as you walk in and you're facing. Actually, this is from the point of view of the judges. You would be on the public gallery side. So on the main floor, you can see that there are desks all around, and then there's here, this is the spot where the witness, it's the witness stand. It is below the public gallery for confidentiality reasons, because you don't want people to see them walking in or out. Then on the second floor, you have 6 individual interpreting booths with the interpreters of every booth in a different setting. Then you have the defense team usually sits to the left-hand side of the judges. Then you have the 3 judges. It's a 3-judge panel with a presiding judge in the middle and 2 on each side. Then to their right, you have the prosecution, and we have the witness opposite the judges. You have the interpreters. You have the court reporters who are on the first level. At the court, we have real-life transcript. Everything that is said in the courtroom in English or French is transcribed in real time and displayed on every single screen in the courtroom and outside. Then you have, it's a novelty, legal representatives of victims who are also sitting to the right of the judges. So these are called participants, and then prosecution defense are parties. This is an actual shot from the booth. You can see the setup is the same, and opposite you have interpreters in every booth. Now, the interpreting process, some of it will sound very familiar if you have been an interpreter or if you know interpreting, but some of it is court-specific. So this is a typical scenario. You have a presiding judge, and then you have the lawyers on each side. The presiding judge will address the parties, participants, and witnesses in English or French. It's up to them, whatever language they're comfortable with. Then what you have is the statement or the intervention from the presiding judge is interpreted by the English or French booth, and it's taken in relay by the situation language interpreter. So if the judge is speaking in English, I'm interpreting in the French booth, and a colleague of mine, say Alfred in the Sango booth, will be taking that from me and interpreting into Sango for the benefit of the witness. Then if the witness is testifying, it's the other way around. The evidence of the witness is interpreted from Sango into French, and then from French into English as well, or directly from the language, depending on who's in the booth. What is very specific about courtroom interpreting, I named it language, legal systems, and other idiosyncratic challenges. We have a Rome Statute that governs what we do. That's our legal framework. But that legal framework is based on, is sort of a hybrid, based on common law and civil law. So you are faced with certain expressions and terms that exist only in one language, not in the other, for example. You are faced with legal terminology on a daily basis. When lawyers make their submissions, they present their arguments, they will use very legal terminology. In their filings, these are the written submissions. When the authorities, which are basically the references, legal references, if they quote from another case law, and the decisions, this is all legal terminology. Then you have another category of knowledge and language requirement, which is the expert witness and the expert subjects. And these can vary from a forensic doctor to a weapons expert to an anthropological expert. It really varies, but it's all technical. You have also the diplomatic/deferential language, which is typical, especially in common law tradition, or also in civil law. where instead of just asking for permission, you'd ask for leave to be granted and not, may I just do something? May it please the court? Some kind of deferential language that you have to obey when you're interpreting. Then, when it comes to interpreters, the conference interpreters working from and into a working language of the court, English or French, they deal with two culturally close languages and cultures. So despite the differences that may exist between French and English, we're still referring to similar things. If I say in English, I I went to the doctors or I called an ambulance, it's very clear. I spoke with the manager. The reference is very clear. So in French, you can visualize that very easily. But the further away you are from, or the farther away you are from that cultural context, the more abstract it becomes. For situational language interpreters working from and into languages of the witness, who may or may not speak exactly the same variety of dialect, and we've seen it in a few cases. In the case of Swahili, we had interpreters who are originally from the DRC who spoke Swahili with a lot of borrowed words from French. Then we had another case, in the Kenya situation, the case of the former vice president of Kenya, where the witnesses spoke Swahili, but it was borrowing heavily from English, and the words may be different, and the choices of words matters there. You have a lot of cultural, religious, ethnic, and regional differences as well, and that may have an impact on the interpretation itself. Then you have to observe register. This matters a lot. If the witness comes in and based on their information sheet, they claim to be illiterate. You don't want them to sound very literate. If they don't understand a word and they say what, you're not supposed to say, I beg your pardon. You just say what, or excuse me, or pardon me. Demeanor and body language is important also. That's why in interpretation you always want to be able to see the speaker, because there are and these vary from culture to culture. In some cultures, not looking somebody straight in the eyes when you're speaking to them may imply that you're hiding or trying to hide something. In other cultures, it is a sign of respect, or maybe a sign of disrespect if you're facing someone and staring them in the eyes. Nervousness can have an impact also on your ability to understand the witness. And this one is the nightmare for almost every interpreter, the compound sentences and double-barreled questions, typical in common law tradition. I'll give you an example. Is it your contention that on the day that the events happened, you were not in the vicinity of the individual who is claimed to have done this? Is that the case? So what are you answering really? Is it your contention, or is it the case? Or so we have to be wary of that as well. Education level, trauma, cultural taboos, these are all very important as well, because the witness who's speaking has lived through trauma, and you have to be sensitive to that. Sometimes they will stop in the middle of a sentence, and that's one of the most difficult things beyond the graphic description. Sometimes if they're recounting an event and all of a sudden they stop and you feel how heavy it is, that can have an impact. Cultural taboos as well. In some cultures, it is very difficult to talk about rape, especially man-on-man rape. It is difficult to talk about anything sexual, and because of fear of stigmatization as well. So that has an impact on the interpretation. Now, some of the interpreting challenges that we face. I distinguish between two categories. One that I call translation proper, meaning the legal concepts. There's no existing equivalent. I'm thinking of one specific example that's been a headache for us in the French booth. Bar table motion. In the legal context, for any information to become evidence, it has to go through a witness, to come from the witness. But occasionally, the two teams, the two parties, defense and prosecution, may get together and agree on a piece of evidence. Then it's called a bar table motion. They just submit a motion to confirm that. That does not exist as a notion or a concept in civil law. So we had to come up with something for that. The difficulty also is with Latin expressions that are hard to translate in certain situation languages, or that may mean something totally different in French and in English. They may sound similar, quid pro quo, et qui pro quo, have nothing to do one with the other. Military challenge in terms of ranks because there's no exact correspondence, and they tend to be different whether you're in the Army or the Navy or the Air Force, and it changes from one language to the other. Medical issues also, gunshot wounds, body parts, you have to be specific about them. We've had to deal with satellite imagery, we've had to deal with call data records for cell phones. You deal with accents, dialects, regionalism, non-native speakers within the courtroom, but outside as well. Meaning that even some of the lawyers or a lot of the lawyers are not native speakers of either French or English, and they express themselves sometimes in a way that is heavily tainted with the original language that they speak. Then there's the other category, which is the behavioral one, speed, when they're reading quotes or statements. Overlapping speakers, they interrupt each other, and then all of a sudden, what do you do? Who do you interpret? And team members who might be typing while somebody is speaking, and it's amplified in your headset. Not providing speaking notes to the interpreters and court reporters in advance, not spelling out things clearly. So these are some of the things that we kind of try to impart on and impress upon the speakers in general. I'm going a bit fast here because I need to get to the other parts. Cognitive overload. This is more in terms of preparation. I will just skip over this part here. How you prepare in the long run so that you don't have to overload your brain when you're working. Practice, and emotional. This one is also very important, especially for situation language interpreters who are from the communities when you're dealing with really graphic testimonies and hard pictures or videos. Okay, so these were the key features of interpretation in the courtroom. Like I said, there are some specific things that we need to keep in mind. Redundancy, repetition. Deliberate ambiguity is one I would like perhaps to highlight. Don't overdo it. If the lawyer is being deliberately ambiguous, you can't over explicit what they're trying to keep implicit. As I mentioned, we have real-time transcripts and they are displayed in the courtroom. So every individual person in the courtroom has access to this. So that adds to the stress level that you have as an interpreter, because as you're saying something, it's being typed real time and they can compare. And the moment they see it printed on the screen, they think it's a translation. So obviously they think back of translation and comparisons. Now, this is the gist of what I wanted to say about this issue: creativity in the face of challenges. This individual here is an accused person from Darfur. And when he appeared as a suspect, he mentioned that his preferred language was Zagawa. Zagawa is not easily spoken at the court. You can't find interpreters easily for this language. But more importantly, every document, including the indictment or the documents containing the charges, as we call them at the ICC, needs to be translated in his language. His lawyer back then was an English speaker. So how do you ensure that they can communicate with each other when they consult each other? So this is the situation in Darfur, the prosecutor versus Abdullah Banda Bakir Nourain. Zagawa, as I mentioned, is one of three main languages in Darfur, including Darfur, Zagawa, and Masalit. It is spoken by a couple of 100,000 people, and there's almost no written form of Zagawa. But more importantly, we have a statutory obligation to provide translation and interpretation in Zagawa. So beyond the courtroom, we also need to provide translation. So here's the situation we were faced with. This was an actual proposal made by the prosecution. It was our suggestion. We came up with the solution and they agreed to it. Because Zagawa, as they claim, has no more than 5,000 words, translating it would be difficult. They suggested we do what we came up with as a solution. The indictment or the document containing the charges is drafted in English, and it's paragraphed. Every paragraph is numbered 1, 2, 3, 4, and so on and so forth. So the solution we found was to provide an audio translation of the Arabic translation with individual files appended to every paragraph, so that when the lawyer sits down with their client and they want to discuss a specific paragraph, all the client has to do is click on a button and listen to the audio file which had the Zagawa translation. So that's the solution we found. But how do you flesh out that solution? You find you identify the potential candidates. Then we provide a very brief aptitude test, which consists in the following. We ask the candidate to introduce themselves in their own situation language to see how fluent they are and if they are comfortable speaking in public. We ask them to explain why they are applying for the position in Arabic, because Arabic was going to be the retour language, and to assess their skill in Arabic. And we ask them to describe what they know about the case and what they think about it in Arabic. Once again, to gauge their Arabic level, but also to assess their degree of involvement in the case, if they have really strongly held opinions about the individual who's before the court or not, and just to assess initially if there's anything to work with or not. Then we ask them to summarize a short speech, Arabic speech in Zaghawa. The speech is made up by us. I designed certain speeches with a few key words and terms to enable us to also to assess the accuracy. So here's a sample speech that I used, for example. Because it deals with Darfur, I basically followed the basic principles of interpreting the 5 W's: who, what, where, when, and so on. So based on actual information gathered from the case file, I drafted this 5-paragraph text with specific events happening in a specific place to a number of residents with specific names of individuals using a specific type of weapon and a specific type of vehicle. The idea behind it is that when the trainee is interpreting in Zagawa, which I do not speak, but which contains a lot of Arabic words, when they will refer to certain things, I will hear them. And I just basically have a checklist. Did you mention, I didn't hear the name of General Hemeti, for example. I didn't hear AK-47 when you were interpreting. I didn't hear Mujahideen Mosque. And that gives you a sense of whether the interpretation is accurate or not. So this is a specific example of or sample of the decision regarding the charges. As I said, it's all numbered and it is translated in Arabic. And here's an actual example of what we did. Then you'd have, so this is Thaniyan, number 2. So paragraph 2, and it says what it says, then you click on it and you get the actual interpretation. Corresponding audio in Zagawa, it's translated and appended to every individual paragraph. Then when the lawyer is sitting with their client, they can just simply refer to that, click on it, and that was the case for the whole document. So that was very, very brief and very quick. I hope I didn't spend too much time on irrelevant details. Just some parting words before I say goodbye. Trials before the ICC deal with facts and circumstances that are remote in time and space. It is a reality. But through language, events are recorded in the field and recounted later on, and the voices of victims are heard. So from the first potential witness interviews and investigations to the final stages of the trial, ICC interpreters, both working languages and situation language interpreters, are at the heart of the judicial process. They are an essential element in ensuring due process. Thank you very much for your attention.
Thank you very much, Ahmed. We really appreciate that. That was fantastic. I just remind you, everybody, that at the end of both presentations, you will be able to ask your questions. Please put your questions in the chat, as some people have been doing so far. And now we're going to our second speaker of the day. Our second speaker is Melinda Gonzalez-Hibner, and I have the privilege to introduce her today here to you. Melinda has had a long interpreting career, but that wasn't actually her plan. She always thought that she could be a university professor. But while in graduate school, she received a MacArthur Fellowship and traveled to Cuba to do fieldwork. While there, she discovered interpreting and fell in love with it instead. Soon after, Melinda became certified by the Colorado State Courts in the United States and by the Administrative Office of the United States Federal Courts. Later, she was qualified as a seminar-level interpreter by the United States Department of State and became certified as an English-Spanish translator by the American Translators Association, ATA. While her interpreting practice has been diverse, covering court, conference, community, and military assignments, she has gravitated towards court interpreting throughout her career. From 2004 to 2006, she was the Court Interpreter Program Administrator for the Colorado State Court System and instituted interpreter certification requirements across that state. In the year 2014, she returned to court interpreting in the United States District Court for the District of New Mexico, where she held a supervisory position for a team of 8 staff interpreters until recently. Along with her interpreting practice, she has participated in court interpreter certification and training programs for the last 22 years at both the state and federal level. A graduate of the University of Texas at Austin and the London School of Economics, Melinda has dedicated her career to improving language access and professional standards for interpreters in the judiciary, not just through her professional practice, but also by serving on the board of directors of the American Translators Association, the National Association of Judiciary Interpreters and Translators in the United States, the Colorado Association of Professional Interpreters, and the Language Interpreting Subcommittee of ASTM, which is the national in the United States equivalent to the ISO. I must add that I've known Melinda for many years. I have had the privilege to teach along with her. She's a fantastic speaker and she's a great interpreter, and it gives me enormous pleasure to give the floor now to my dear friend and colleague, Melinda Gonzalez-Hibner.
Thank you, Tony, very much for that lovely introduction. And before I start, I have to say, Ahmed, your presentation was awesome. I hope one day I can go to the International Criminal Court and be guided by you on site. What you do is incredible, and I commend you for it. And I just loved all of the information that you provided us with. So thank you. It's a different world from my own. I am going to share my PowerPoint now, everybody, so that we're on the same screen. It's taking a little while. I hope you can see it now.
We can, Melinda, thank you.
Wonderful. Thank you for confirming, Katerina. So as Tony stated, I work for the federal court, that's really shorthand, for the District of New Mexico. Our formal and official name is the United States District Court for the District of New Mexico. And so this is our building in Albuquerque. So this is a very different world from the one that Ahmed just described. Completely different, and yet interpreters have to do a lot of the same things. Our particular issues and challenges are very different from the ones that Ahmed and his team face. But let me just start with a brief description of what the District of New Mexico is. So our court, like every district court, is a trial court. It is what in other countries is also known as the court of first instance. So this is where cases come, trials are had, and then if there are appeals, they move up the ladder. So We are a trial court, and in our district, we have 5 courthouses. And the first image that I showed you is the court in Albuquerque, where I work. Now, you're probably wondering, Melinda, what does that mean, Article 3, district judges? That means that they were appointed, they were proposed by the president, they were confirmed by Congress, the Senate, actually, and these are lifelong positions. A Title III judge in the United States, in the federal system, is a judge that will serve without having to ever be elected, renamed, or anything like that. They are very powerful, and these lifetime appointments were designed to serve as a check and balance, right? The judiciary is supposed to be serving as a check for the executive and the congressional branch. So that was the purpose, and that still exists. Of course, those of you that follow news in the United States know that it is a politicized process because Republican presidents nominate judges and Democratic presidents nominate judges, and Senates confirm mostly, but oftentimes, sometimes nominees that the local state senators propose don't even make it to a confirmation hearing because of political issues. Nevertheless, I can say in all the years that I've worked in federal court, it is very gratifying to see that judges actually kind of leave politics out the door in the districts that I've worked, and they follow the law. And it is always been my honor to be a witness to that. So we have 11 Article 3 district judges, and then we have 12 magistrate judges. The difference there is that the magistrate judges are named, they're appointed by the district judges, and they serve for 8 years. And they basically are there to assist with the initial hearings when people come for the first time and find out about the pending charges, the rights that they have in our judicial system. In our district, they also preside over the changes of plea. That's a very roundabout legal way of saying the hearing when you recognize and accept your guilt, you accept your responsibility for whatever crime was pending. And our district judges preside over trials and sentencings. And in this case, I am speaking of criminal matters. In the United States, at the federal level, interpreters are provided only for criminal cases. There are a few exceptions for habeas corpus cases, things that deal with civil rights. Those are pretty unique. Hague Convention cases, those will be provided interpreters. But civil cases, by and large, do not have the privilege of receiving free interpretation. The parties must they must hire their own interpreters. Interestingly, at the state level, all the state courts, not all of them, I'm making a very incorrect generalization here, but in state courts, and I would say about a third of the jurisdictions, interpreters are provided for every type of case. It doesn't matter if it's civil, if it's criminal, if it's a domestic violence case, if it's a restraining order, if it's an issue of competency, everyone is provided an interpreter. In other states, they don't, but they are mandated to provide interpreters in criminal cases because there's a possible loss of liberty. So that has always been part of due process, that you can be present at whatever hearing is going to affect your liberty. And being present has been interpreted to mean present linguistically, that you can hear whatever is being said in a language that you understand. Do you have the right to understand what's happening? Actually, no. It's not the interpreter's responsibility. We have code of ethics. It is very similar in all states and also at the federal level. And we are compelled and mandated to maintain register, which means oftentimes we speak in ways that are not necessarily intelligible to defendants that don't have the necessary education to understand legal terminology. And that is an issue that we contend with. There are huge arguments being had in the interpreter community in the United States about this particular part of our code of ethics, but I won't go there. I just share that with you. So back to New Mexico and who we are. The kinds of cases that we hear are obviously very, very different from the cases that come before the International Court. We are a border court, which means we have many, many cases that deal with illegal reentry. I should make something else clear because I know that my audience this morning is not US based, wonderfully. So let me just also clarify that in federal court, the only cases that are heard, obviously, are cases that deal with, that are violations of federal law. It seems kind of logical, but what that means in the United States is that I don't hear, horrible murder cases. I don't interpret for murder cases unless it happened at a federal penitentiary, because then it's under federal jurisdiction, or that person was murdered in Alabama and put in the back of a car and transported all the way to New Mexico. That would come to my courthouse because they cross state lines. Anything that involves crossing state lines immediately becomes a federal matter. So typically, violent, hard, heinous crimes are heard at the state level, in the locality where they occurred. The federal courts hear cases that involve federal law violations. And so in New Mexico, what do we interpreters mostly interpret? We interpret cases dealing with immigration violations, people that are entering this country illegally, or much more frequently re-entering it illegally, meaning they have already been deported and they have returned, and now there's a record and they have re-entered. So we hear those cases, and we also hear cases that deal with drug trafficking. Why? Because there's all kinds of federal laws that prohibit drug trafficking. So those are mostly our cases in New Mexico. If we go to Florida, they're going to have other kinds of cases because they have a huge Spanish-speaking population that's legally there, that have been there forever. And so they're committing perhaps other kinds of crimes, not perhaps, definitely, other kinds of crimes, and require interpreting. There's, things that might happen at sea, and they land on the Florida coast and they require interpreters. So the federal courts in different jurisdictions might hear a slightly different sort of case, but in New Mexico, it's really immigration and drugs. We have a very high volume of cases, and what do I mean by that? What do I mean by that? We count our activities in terms of events. Every event, every court hearing, every interview with probation is deemed an event. And this fiscal year that just ended on September the 30th, the fiscal year for 2025, we actually had over 20,000 events in my district. So that's considered a high volume. So you can imagine how long that might take. Las Cruces, which is our courthouse that is closest to the border, typically on Monday mornings when, agents have been arresting people over the weekend, will have in their initials docket the cases that are heard for the first time, where people again are informed of the charges against them and the rights that they have in our judicial system. We've had up to 100 in one morning. So you can imagine how busy that is, because 100 people need to be read their complaints. We proceed by indictment or by complaint, but typically it's complaints. These are documents, what the charges that need to be read to all of these defendants, and we typically have an hour to do it. The U.S. Marshals bring the defendants, and actually less than an hour. We have half an hour. We have 30 minutes, 35 minutes. So in Las Cruces, we have a wonderful team of 6 interpreters. They typically all show up early in the morning, or at least 4 of them, and they team interpret. We have documents in hand. This is old style, guys, because there's so many different defendants. We're not using equipment for that. We're reading, we're doing sight interpretation, so that people will know what the charges are. Anyway, busy. I already told you that we only provide interpretation for criminal cases, so I won't repeat that. Our district is unique. Not completely unique, but unique among many, because the judges in our district feel like if we can provide interpreting for family members who require an interpreter, even though the defendant may not, because we have juveniles, of course, young people that do speak English and parents don't, that if we staff interpreters are available, we should provide the service. In other districts, this is not done because it's not legally mandated. Victims have a right to that, but not families of defendants. But in our district, when we can, we do. We don't hire contractors for that purpose, but we provide the service when we're able. So to give you an idea, I told you high volume. It is high volume. And this last year, again, the last fiscal year, we provided interpretation for 37 different languages. Now, I did the math when I prepared this, and it shocked me, because languages other than Spanish, which is how we talk in New Mexico about the services that we provide, it's either Spanish or languages other than Spanish. That's our division. Languages other than Spanish demand so much of our attention, because we have to find the interpreters. And they're not always easily found. So we have to find them, and then we have to do all the contracting work. So I'm not sure if Ahmed has to mess with those kinds of things, but we do. Our team puts them under contract. We do procurement. We have to follow all these rules about how to pay properly and how to put people under contract and ask for documents. It's administratively quite cumbersome. So in my mind, we had many cases that required languages other than Spanish, and we do, but in the scheme of things, they represent only 1% of the cases that we cover. And that really, I learned something in preparing this for all of you. I won't read you all the languages that are listed. Hopefully you can see them, but you see that they're from various parts of the world. And even though, yes, they require a lot of our attention, and we work very hard on them, they're really a very small part of what we do. What we do is mostly English, Spanish. Now you'll see some languages there. Some of these languages have available to us professionally trained professional interpreters that have training and education. They have credentials. Many others, we don't have such a thing because there is no training available for those languages. So who interprets? Well, if you're a Spanish interpreter or you are a Navajo interpreter, the only people working in our courthouse are federally certified court interpreters. That means the United States is different. We don't have training requirements. We have certification requirements. You must have demonstrated your skills in a standardized exam that is competency-based, and it's written and oral. At the federal level, the pass rate is actually very low. It's below 20%, but it's really below 20% for the written and then below 20% for the oral. So of the 20% that pass the written, then 20% pass the oral. So it's really much lower as a global rate. So federally certified court interpreters interpret for Spanish and Navajo. And then for some of the other languages, many of the other languages from Asia, Europe, the Middle East and North Africa, who do we use? We can use state court certified interpreters, because in the state courts, they offer certification to 17 languages. So there's, Mandarin and French and Vietnamese. The federal court doesn't certify those languages. They only certify Spanish interpreters now, but the state courts do. So we avail ourselves of those interpreters, knowing that they have demonstrated interpreting skills in all three modes of interpretation. The other credentials that are accepted, interestingly, by the Administrative Office of the United States are Department of State, seminar or conference level interpreters, and IEC members. So all of you IEC members, you will get paid the professionally qualified rate if you come work for the federal court, because they recognize that credential as a valid representation of skill. Indigenous languages. There's nothing like this. I don't think IEC probably has Indigenous language interpreters among them. Maybe you guys do, and I am ignorant of this. Maybe you do. I hope you do. That would be a good thing for me to know. But the state courts don't test them. So what we have are some training programs that are sort of informal in the United States. Organizations train interpreters here in the United States. And then there are more formal programs in places like Mexico, where they do use Indigenous language interpreters. And so they have training programs, and that has become more common as of the last 10, 15, 20 years. But in the United States, it's really, really hard to find people that have had training. So we hire those interpreters directly, or we contract with agencies who find them for us. And those interpreters might actually be providing services from Mexico or Guatemala, which is where we find Indigenous speakers. So what do we do? Since I know our audience may not know what it is that we do in federal court. Well, we do site interpretation, also known as site translation. We have to read the charging documents. That's our responsibility at the very beginning of the case. Once criminal defendants are assigned defense attorney representation, it becomes the responsibility of their defense attorney to provide for whatever is required in terms of translation from there on out. We do translate, when we're on staff, documents that the court requires. There's letters sent to judges asking for mercy, letters from families, letters from experts. That comes to the staff unit. And if it's a language, because all staffers are Spanish English, that's really the language that's needed. In New Mexico, if we have a letter written in Turkish, we will find a contractor, hire them, and get the translation done. But it falls on the interpreter unit to get that done. We do simultaneous interpretation, really only for the defendant. This is a huge difference with the criminal court. We interpret simultaneously for the defendant, and everything that is going to go on the record that is being captured by the court reporter, that the judge is going to hear, that the attorneys are going to hear, we must interpret into English, and we do that consecutively. We do not use the simultaneous mode. The only person with headphones is going to be the defendant, also known as the limited English proficient person. We use relay interpreting with some Indigenous languages who only are able to, or I shouldn't put it that way, but who can interpret. For example, we had a request for Zoque. It is an Indigenous language of the very southern part of Mexico. So we were able to find an interpreter that could interpret between Zoque and Spanish. So then the staff interpreters who work Spanish and English will provide relay interpretation. I have copied some of the descriptions of what court interpreters are supposed to do according to judiciary policy, just to give you an idea. We have some ability to contribute our ideas and our opinions and our recommendations if they ask us about interpreting matters and how things should be done, which is actually a wonderful thing. It doesn't always happen. It rarely happens. The system is kind of down to a T, but it is established in the Guide to Judiciary Policy that we can serve as experts for the court. I wanted to address the interpreting for witnesses because also there's differences with how things are done. So during court hearings, the court interpreters, us, the official court interpreters, we interpret for prosecution witnesses, we interpret for defense witnesses. If we interpret for the prosecution in the District of New Mexico, we actually get reimbursement from the Department of Justice, from the U.S. Attorney's Office. Per law, we're not supposed to be providing services for free to the prosecution to make their case, right? So if we are providing interpreters for one of their witnesses to make their case, it's not considered to be a neutral posture by the court. So we are there, we provide those services because everybody knows that they can rely on our professionalism and our skills, but we are reimbursed for that service. That is pretty unique amongst federal courts. In most jurisdictions, the prosecution has to provide their own interpreter, and they do. Unfortunately, they don't follow the requirements in terms of skill and certification that the court does. So we, the official court interpreters, might find ourselves in a position where we're listening to an interpretation because we're there for the defendant. So we're doing our simultaneous interpretation of the proceedings. And then a witness for the prosecution appears with their own interpreter, and that interpreter is actually perhaps not very competent in making all sorts of mistakes. And according to our ethical code, we must remain silent. We don't provide our opinions unless we're asked for them. So, you know, I think all court interpreters who are certified and very qualified have at some point in their life gritted their teeth and, you know, just grabbed onto the table to remain silent as they see terrible interpretation being perpetrated before their very eyes, because they're really obligated not to say anything unless somebody asks for their opinion, for their expert opinion. In New Mexico, we have gone around that legally and cleanly by providing the service ourselves and having an agreement with the prosecution, with the U.S. Attorney's Office, to be reimbursed for the service. But we are pretty unique in that regard. Continuing on, things that are special about New Mexico because of the amount of cases, the number of cases, the number of defendants that we have to deal with and really deal with in a timely manner, because there's all kinds of limits. You know, unlike Ahmed, I realize you are dealing with cases that are in the past, and that has all sorts of challenges. We're dealing with cases that just occurred, and we are legally bound to have them heard within timelines. There are legal timelines so that cases aren't languishing. So because of that, we are under pressure as a court to deal with all these cases, and we interpreters along with that. So in our court, New Mexico, again, they were pretty creative, our judges. I don't know that interpreters like the solution, but it is what it is. They will call multiple defendants at once. Let's say 8 defendants. I don't think they ever call more than 8 for hearings. When these people are going to plead guilty, they're going to accept responsibility for the crime with which they were charged. And they will call them as a group and they will say, okay, you're charged with illegal reentry on this date and that date. And do you understand that you have a right to go to trial? And they're awaiting the responses of the defendants, and the defendants all answer individually, they must, but me, the interpreter, I will reply yes by all. I don't think we save tons of time, but in the minds of the judges, we do. And so this is very difficult, you can't imagine, because there's some defendants that'll say, yes. Another one will say, yes, yeah. The other one might say, yes, Your Honor. The other one will say, well, yeah, okay. So you've got 8 people saying different things, but the court is expecting us to say yes by all. If they all agree to say yes by all, and that's what goes on the record. Some judges are more adept with this because they will actually call out the names of each defendant, and then you can say whatever the defendant said. But if they call them as a group and they're expecting the yes by all, that's what we do. When they ask about their health conditions, because this is a question that is asked to see if they are in a position to accept responsibility. They'll ask them if they have health issues, if they've taken medication. You can imagine they're asking 8 people. We might have 8 answers, and you, the interpreter, need to know who said what. So we're madly taking notes to know that it was Mr. So-and-so and Mr. So-and-so and Mr. So-and-so, and he had high blood pressure, and the other one hasn't taken any meds, and the other one had to take medication to sleep. So it's a little, that is hard for us. Our interpreters in Las Cruces are pros at this, so they have developed all kinds of systems to deal with it, but it's pretty unique. In most courts, it is one defendant at a time. In New Mexico, we are forced to do this to make sure that all these cases are not solved, but resolved and heard on a timely basis. The other thing that is not absolutely unique in our district, but we are in the minority, and it is controversial, and classically trained interpreters who have had formal training, and those are not in the majority in the United States because we don't have actually a lot of places to get trained, really don't approve of this practice. Okay, to what am I referring? When we do use consecutive interpretation, because we have witness testimony in our district, again, to shave time, to move through things faster, when the question is asked of the witness, we ask that question in simultaneous mode. When the witness gives their answer, we provide that answer in consecutive mode. So the logic here is that the record is being made in English. So the question is asked in English. It is going on the record. A court reporter is taking it down. It doesn't matter what the interpreter is saying because it's not going on the record because you're saying it in Spanish. And forgive me, I'm using only Spanish because it's 99% of our cases. But even if it's Mixteco, whatever language it is, that's not going on the record. The court reporter is not capable of taking down another language. So the record is made of the question in English. Then the witness or the defendant will provide an answer in non-English. That will be recorded in the courtrooms that have digital recordings. So it will be recorded, but not all courtrooms do that. Some courtrooms just have a live court reporter, and they will not take down that answer. It's not in English. And I, the interpreter, will provide my interpretation after that person has spoken. We don't speak at once because no equipment is used. In most courtrooms in the United States, the interpreter that's doing that kind of interpretation is standing next to the witness or the defendant at the witness stand. So the person that's providing testimony is seated, and the interpreter can be seated next to them or standing next to them. In old courthouses, interpreters have to project their voice to an entire courtroom because they don't have a mic. Or they are given a mic now, and you speak to the mic so that your voice will be captured. In the District of New Mexico, we are very fortunate. Our court invested in simultaneous equipment, the IC2 consoles that are used by conference interpreters. We do not have booths. We have a table, a sign table that's next to the bench where the judge sits and the courtroom deputy sits and the court reporter sits. We have a table at their side where we have an IC2 unit. And so we don't stand over there by the witness stand. We actually are using equipment. We ask our question in the simultaneous mode. The witness over there at the witness stand provides their answer. We wait, and then we provide our interpretation in consecutive mode using the broadcast function. So it comes out over the courtroom loud and clear. I can save my voice. I can modulate. I can provide the same intonation. Ahmed did a beautiful job of describing and reminding us all of the obligations we have to convey not just the words, but also all these paralinguistic elements that go with the volume and the sentiment of the witness. We can do that much more gracefully when we have equipment and we're not trying to yell over a courtroom to make sure that people can hear us. So we do that in New Mexico. So what is controversial? What's controversial is that typically consecutive requires that you do consecutive of the question and the answer, meaning that you do full-on traditional consecutive of both things. In New Mexico, we're not doing that. We're doing this hybrid thing where I'm interpreting simultaneously the question to save some time, honestly, and then I provide the consecutive for the answer, and that is going on the record cleanly. Judges here like it, have requested it, expect it. It is good for the interpreters in the sense that we get to sit at the interpreter table with your teammate. So if you're making mistakes, you have somebody catching your mistakes, making a note of them. You can see them. You can correct them seamlessly. You can manage the witness and say, sir, please give me a minute. I need to interpret what you have said, which you cannot do when you're standing in front of everyone, projecting your voice. And also, we used to teach, and we still do, at the court interpreter orientations, how to tap people on the shoulder or make signs. Stop, stop. Okay, we don't have to do that. When you have equipment, you simply, and I don't know why my hand is up. Sorry, I didn't mean to raise my hand. So it provides a very elegant solution. We can manage witness testimony and provide the service, but I just wanted to share that it is not something that's done across the United States, but we do it and it works. I just wanted you to see a courtroom. It's not one of our courtrooms, but this is it is a federal courtroom, and they're similar. They tend to build them in the same manner. The way people get arranged in our courtrooms is you have the judge, and over there at the bench, the judge will have a courtroom deputy. That's the person that's managing the courtroom. The court reporter will be there. The witness stand will be there as well. There's always two tables, one for defense, one for prosecution. How do we know who's who? Well, the prosecution is always the table that's nearest the jury, because they represent the people, and the people are also represented by the jury. So when you're a new interpreter and you're trying to figure out what table should I go to, you go to the table that's farthest away from the jury, because that's going to be defense. We interpreters in the federal courthouse in New Mexico don't have to do any of that because there's an interpreter table. So we don't sit next to the defendant or anybody else. We sit with ourselves and probation officers. It is a pretty unique, and it is actually wonderful. It provides us distance, and it makes our job a lot easier. You know, when we stand next to the witness, the jury invariably will look at the interpreter. So if you're a handsome interpreter, if you're a well-dressed interpreter, if you're a tall, a short, or whatever interpreter. There were once comments about the female interpreter who wasn't wearing a brassiere and why she didn't return, probably because somebody had noticed and they didn't like that. And really, the jury needs to be looking at the witness, not the interpreter. And so having this table that is away from the witness is actually a wonderful thing for us, because we really are removed and the jury does look at the witness. So what have we done in New Mexico? We provide team interpreting from the courtroom, from this table with our little IC2 unit. for events that are expected to last longer than an hour. You should know that these practices are kind of sort of getting generalized in the United States, but they're not generalized. There are places where people are really working without having the benefit of a team. We provide charging documents, all the documents that we can, although I was impressed by the witness statements, Ahmed. We do not get witness statements. We have no idea what the witness is going to say. So, you know, we know what the case is about, and we prepare and we've interpreted for the expert witnesses, and you build your glossary as you go. We do not get the statements. I was very jealous of that. But we do have the charging documents. We have the colloquies that the judges use typically for the changes of plea hearings, the things that are always the same. We provide those to our interpreters that are contractors and in languages other than Spanish so that they may prepare. Now, as I said, we have some indigenous languages where the interpreter doesn't know English. They know English, I mean, they know Spanish, sorry, they know Spanish and their indigenous language. So our team has taken it upon themselves to make translations of the English documents into Spanish so that those interpreters have access to the information what is being said. Now they have their own challenges, of course, because they're going to have to figure out how to say this in Mixteco when there probably aren't any direct equivalents. And unlike Ahmed, who has the wonderful privilege of training interpreters, we cannot train interpreters in federal court. That is like completely outside our remit. So all we can do is ask what training they have had. Have they ever done it before? Have they worked in a court, in a state court, a federal court, etc.? We cannot provide a lot of training. We do a brief orientation so that they'll know how to handle Zoom, and we provide them documents and hope very much that they can prepare. And of course, with experience, we learn who the interpreters are that are very adept, very smart, that manage situations, and that the defendants are all responding cogently to the questions that are asked of the court. And so we learn about the interpreters and who's doing a really good job. And we continue to hire those people. So I already told you we have IC2 consoles. That's how we work in the District of New Mexico, that we use them for witness testimony. We do a lot of Zoom interpreting for the languages other than Spanish because most of those, well, all of them live outside of New Mexico. In New Mexico, we have Navajo, we have Zuni, we have ancestral languages of New Mexico, but we don't have indigenous languages of Mesoamerica and Central America. So those interpreters call in. There are many interpreters in the United States who interpret indigenous languages because they've immigrated to the US. So we tend to use them because they're in the US and the connectivity is going to be better. But they're not in New Mexico. So they are appearing via Zoom. Zoom interpreter channel really brought us forward to the 21st century, because before we had to do it over the phone. And I don't know if any of you have had to interpret over the phone, but you can imagine what it's like. It's all consecutive and you have no visual cues at all. So Zoom has been wonderful. Now to just explain a little bit of what we interpreters in the courts in the United States, the kinds of things that we need to think about. And I'm not going through the whole code of ethics because it's unnecessary, but we are officers of the court. We are deemed officers of the court, and that simply means you have to speak with the truth, and you are a public servant, and you must protect the dignity of the court and of the judicial system. And you are so, even if you're not staff, even if you're a contractor, even if you don't work directly you are working for the court, but you haven't taken an oath as a judicial employee. You're still an officer of the court, and you're expected to act as such. Part of being an officer of the court, and this isn't even the interpreter's code of ethics, is that you are impartial at all times because the court is impartial. You are an officer of the court, you act like the judge, you are impartial, and you must protect your neutrality, whether it's real But you must also protect it in it being perceived. So even if you are neutral and you know you're neutral, but you're acting like you're not, that's a problem. You have to act it as well, right? So you're not super friendly with defense, you're not super friendly with prosecution, you're super friendly with other interpreters, and you keep to your part of this. We have a code. Like I said, I'm not going to give you all of it, but I didn't know if this might be of interest to you. So canon number 1, meaning the most important one, the first one and principal one, is that we must be accurate and complete. In court interpreter terms in the United States, that means that you maintain register. So if they're saying very elegant, complicated things, that's what you're saying. And if they're using profanity, you're using profanity. You keep it at the exact same level, and you cannot omit things. You must give the whole entire message, even when it makes no sense whatsoever. And Ahmed was talking about that as well. We really have to be accurate and complete. I chose this other part of our code of ethics because we talked about interpreters who might come from small communities and may know the people there that they are interpreting for. They're still under an obligation to remain neutral. And typically the way that this is achieved is not just by talking to the interpreter, but by putting on the record with the court in open session that Madam Interpreter or Mr. Interpreter knows so-and-so or so-and-so, and they ask on the record, they ask the interpreter on the record, Madam Interpreter, Mr. Interpreter, we are aware that this and this and this is the case. Are you aware of your obligation of remaining neutral and impartial? And do you commit to respecting the code of ethics and doing whatever it is that the parties expect? And so the interpreter has to, on the record, say, yes, I know that I'm going to interpret everything. I'm not going to add or subtract anything. And the parties have to agree. Just like Ahmed said, the parties are the prosecution, the defense. This has to be by agreement of the parties and put on the record. So that's how those things are handled in criminal court in the US. Conflicts of interest, it's the same sort of thing. We repeat, as you can see, the whole thing about real or perceived. You must report. It doesn't matter what you think, what your opinion is, you think it's no problem whatsoever. You need to inform somebody, and somebody else, meaning the court, has to make the determination that there is or there isn't a conflict of interest. But we avoid even perceived conflicts of interest. If there's a perceived, they have to clarify it and put it on the record. I added this not because it's important for us to know that we don't receive gifts. All of us know this. I think that's a pretty generalized expectation of professional interpreters. I added it for the italicized part, that in those languages where there are very few providers, you are allowed, with the permission of the court, to work for the court, and then maybe later for one of the parties, doing the tape transcription and translation, whatever's required. It is allowed because maybe you're the only provider in that language. The court understands this. As long as this is done with the agreement of the parties and on the record, it can be done. Challenges, it's pretty obvious by now, by what I've been saying, that not all of the interpreters that work in our district or in all of the districts in the United States are equally situated. We don't have the same access to training. We don't have the same access to resources. We maybe never got any training in terms of protocol and how we're supposed to behave in a courtroom because it simply wasn't available. There's issues with terminology and equivalence of legal terminology and judicial system, the whole entire thing. Technology, which we use a lot, is not always reliable, particularly when we have interpreters appearing from other parts of the world. Sometimes best interpreting practices are challenged. In our case, by our high volume and having to do these group hearings, which work and we get them done and we get them well done. But if you ask me, Melinda, what would you like? I'd like a one-by-one thing. I really would. But you know, I'm not the one running all these things. And in our case, but we can't really provide training for contractors. That's something that's not allowed because it's simply not allowed. I won't go into it. There's a lot of legal reasons why not. So solutions, well, we keep working on them. We share information with our contractors, and we have developed processes with the courtroom personnel. We have to work with them very closely, particularly with Zoom and the calling of cases and these group cases. You can imagine we're going to have a case, I think, this week or the next, where we have 4 Tzotzil speakers, and they are going to call them together as a group. So there's 4 Tzotzil speakers, and then in this particular case, we're lucky because there's 2 Tzotzil interpreters in the United States that don't require relay. They can go from English to Tzotzil and Tzotzil to English, and they're both PhDs who did research in the area of the world where Tzotzil is spoken. So they are very capable of dealing with Zoom, of dealing with issues because they have a lot of training, perhaps not in interpreting, but in other sorts of areas that allow them to think and process and problem solve quickly. So they handle groups pretty well because they've understood what our court expects. But then for interpreters that are doing relay, who really have never been in a courtroom in the United States, and you want them not just to do relay, but to figure out that there's 4 defendants being called at once and that you're supposed to say yes by all for all 4 of them. It is quite challenging. And the Spanish interpreters, the staff interpreters are always present when we have these kinds of hearings. And so they provide support to the contractors, to the interpreters of Indigenous languages. But we can't do full-on training to walk them through it and, you know, do 2 days of practice. That doesn't happen. You can only do it as it's happening. You give them some guidance. We explain it to them via email, but that's all we can do. It's a solution. It's not perfect, but it's what we have. So thank you very much for listening to me, and I would love to answer questions if you have any. And I will unshare.
Thank you, Melinda. That was amazing. I'd like to thank both our speakers. We have had an outpouring of gratitude and compliments from all participants. There is a question that has been asked about whether AIC will help to qualify interpreters to work in different court settings, and the answer is no. The Legal Interpreting Committee will not be holding such trainings, nor will the ATPD for the moment. We'll see how that might shape up in the future, but at the moment, we do not envisage it. So as we have gone a bit beyond the time that we had originally envisaged, we will be taking 1 question for each speaker, and then we'll take 1 question that we'll put to both speakers. And I will start with Ahmed, actually. This is a question that has been answered on the chat, but it has to do with the status of Russian in the ICC. And it's a question that I think it would be very interesting to hear on mic also. And then I'll be handing over to Tony, who will be asking Melinda the question.
Yeah, sorry, could you repeat the question? I'm not sure I caught it.
It was a question that you've already answered on the chat, and it has to do with Russian. What is the status of Russian in the ICC?
Yeah, well, Russian is one of the official languages of the UN, and it is an official language at the ICC. It is recognized as such. So that means that not every document will be translated into Russian, but it is possible to, at some point, if we have a trial involving Russian, to have somebody ask for leave to speak in Russian in the courtroom. It's happened in the past. We've had a defense lawyer ask for permission to speak in Arabic, and they were granted that permission. And one of the prosecutors, who's a Spanish speaker, also requested special leave to ask their question in Spanish of a witness, and it was granted. So that's the main difference. It is official, but it's not working language. The only French and English are working languages on a daily basis.
Thank you very much, Ahmed. Now the question to Melinda is the following. Melinda, do you recruit Mexican indigenous languages interpreters from the Mexican Registry of Accredited Interpreters, or do you resort to interpreters who are only on U.S. soil?
Let me unmute. We do not actively recruit from Mexico or anywhere else that is not the United States. We have hired interpreters from other countries, but administratively, it's a nightmare. We have to have all kinds of dispensation, and the payments go through the US Treasury, and they typically take over 90 days. So just to make things easier, administratively speaking and legally speaking, we focus on hiring interpreters that are in the United States or agencies that are in the United States who are free to hire interpreters in other countries, but they deal with the administrative procedures of getting those interpreters paid outside of the United States, because we just pay the agency, which is US based. So that is what has ended up happening. We have done it in the past, but it was so incredibly difficult that if we can do it with US based agencies or interpreters, that's what we do.
Thank you very much, Melinda. And now we have a final question. This question is addressed to both of you. And the question is the following. You have already mentioned some of this when you describe your places of work, but are the interpreters, when they are working, visible to the audience in the public gallery or to the audience in the courtroom? And if so, how do you as interpreters feel about that, of being visible while you are working? Ahmed, you want to start, please?
Sure. Yes, I saw that question. It's an excellent question. I think it was Eva who asked it. Yes, we are visible, very much so, especially if you switch the lights on, then, and we are at level with the gallery, the public gallery. How do I feel about it? I'll be very diplomatic about it. I'll give you one of two answers. The second one I will rather not give, because it is not up to me to make that decision. The second one is, yes, I am happy about it for the most part, because the more visible interpreters are, the more they'll be taken into account as part of the proceedings. And it does work really well for us at the ICC, because we are part of the proceedings. When something is not going well, I can switch my mic on and say message from the French booth interpreter, and the presiding judge will look up and I'll say, would you kindly ask the witness to slow down, or would you please ask the witness to repeat? And that visual contact helps us also promote our profession. So to that extent, yes. There are other concerns, of course, but I would rather not answer that question, that part of the question.
Thank you very much, Ahmed. Melinda.
So I think you guys all realized when I showed you our courtroom, we're there. Yeah, we are very visible, and we're happy about being visible. But I'm also very happy, and I think most of the people on my team are very happy that we're not as visible as we used to be when we were standing next to the witness stand. Some interpreters really like that, but it really affects the jury's perception. That's a little bit too visible, because we often overwhelm the witness. We take up a lot more space, and we're the ones speaking in English. So just in terms of fairness and the witness being perceived for themselves, I think it is very beneficial that we're seated away from them, but we are visible. We're seated there in the courtroom, and when we intervene, we are also listened to. Ahmed, I'm happy to say, we try not to. Part of our code of ethics is to be unobtrusive, but if it's getting in the way of your accurate and complete interpretation, and you really need a clarification, or somebody is walking away from a mic and you can't hear them, yes, we're obligated to speak up and say, Your Honor, the interpreter would request that Mr. whomever, attorney, please walk back to the mic. We are often beat to that, though, by the court reporters. because they can't hear either. So I don't know that I answered all the parts of the question.
Thank you very much, Melinda. I appreciate that. Thank you both for answering the questions. And oh, Ahmed is going to add something. Go ahead,
Yeah,
please.
just a very quick question. First of all, Melinda, thank you for an excellent presentation. Really, really interesting. My question is about consecutive interpretation in the courtroom in the US. Have you considered, or is it even possible to consider at some point, a sort of a hybrid consecutive, meaning that the response would be given by the witness, recorded, and then you just deliver it by listening to it instead of like a recorded version of it in simultaneous mode to make it a bit faster?
Well, what I would say is that if I'm understanding and visualizing correctly what you're describing, Ahmed, there are interpreters who are at the forefront of technology who do record the witness with their own personal equipment. And that's another issue because some courtrooms won't allow this. But if they allow you to bring your own personal recording equipment, some interpreters actually do record what the witness is saying and then provide a simultaneous interpretation, rendering of the recording. So that is done. It doesn't save a lot of time though, because you still have to wait for the witness to finish. Now, probably your consecutive and my consecutive are a little bit different in the sense that in the courtroom, décalage, unfortunately, is frowned upon hugely. As soon as the witness is done speaking, I mean, within, and I'm not exaggerating, within 3 seconds, and that's a lot, I'm interpreting. So the recording doesn't save me time because then now you'll get really fast. It doesn't save you time because you still have to wait for the witness to finish and then you must begin interpreting. What it saves is omissions and errors because now you have a recording and you're going simultaneously instead of depending on your notes and your memory, which is what we have to do without the equipment. But if we're doing consecutive, it more likely than not, over 99% of cases means I'm working with somebody. I have a teammate. And when I have a colleague, then I breathe easy because whatever I omit or whatever I made a mistake in, I will have a little note and I will be able to change it right then and there. Your Honor, for the record, the interpreter would like to correct her previous rendition of blah, blah, blah. She should have said X. And we do it right there on the spot and immediately because I don't, and just for you, for the people that have never worked in a US courtroom and you're in a booth, you always have your teammate. But in the majority of the United States courtrooms, you're standing over there at the witness stand next to the witness, and your teammate, whoever you're working with, is not with you. They're seated at wherever they had the interpreters sit. So when you make your mistakes, when your colleague wants to assist you, sometimes it's easy and sometimes it's absolutely horrible. They have to stand up, not do that. You can't because you're in a courtroom, but you have to say something to the effect of, Your Honor, may the interpreter consult with her colleague about a linguistic matter. And some judges, and I lived through it, will say, no, please have a seat. And then your poor colleague is thinking, what did I say? Where did I screw up? They have no idea. They just know they did something and you can't even tell them. So making pictures, but so that's consecutive. So thank you for the suggestion. Some people do it, but they don't do it to save time. They're doing it more to preserve accuracy.
Thank you, Melinda. Thank you, Ahmed. And now I'm going to give the floor back to Katerina.
Thank you. I appreciate that in court interpreting you might be more visible, but our interpreters were not visible today. They were very invisible, but I think you made their lives quite difficult at certain points because the issues were very delicate, and I think we really need to applaud them. So in the French-English booth, we had Roselyne Hague, Steve Locanon, and Clovis Neo-Uka. I hope that I've been pronouncing the names correctly. And in the Spanish booth, Spanish-English, Ana Lucia Mendoza, Alexandra Yang, and Carola Leckmacher. So thank you very much for interpreting. And I'd like to thank once again our speakers, Ahmed and Melinda. An amazing presentation. You've done us proud. You've given us so much food for thought. And I think that you've helped interpreters go into the court with a fresh mindset. Thank you very much.
Thank you
Thank you
very
for
much,
having us.
everybody. And this officially ends the webinar. Thank you for spending part of your Sunday with us, and we hope to see you soon with another event of AIC LIC and AIC USA. Thank you very much.